Hello everyone, myself Veren Sharma, Faculty for Polity and Governance at Vajiram and Ravi. In the today's lecture, we are going to discuss about the removal of judges of Supreme Court and High Court. It is one of the important topic in the sense of current affairs. As you have seen in the last few months, there are discussions regarding removal of a High Court judge, Justice Sharma, and in context of that, it become an important portion for prelims. So let us discuss in detail what are the grounds for removal, what is the procedure for removal, what kind of majority required, and what will be the overall composition for committee in order to remove the judges. Let's understand this topic from basics. Removal of judges of Supreme Court and High Court. With respect to this removal, we will understand it in sense of constitutional provision. What are the grounds and what is the procedure? Because the judiciary in India is integrated judiciary, single and unified judiciary, these terms are utilized. Therefore, the higher judiciary, High Court and Supreme Court, their removal procedure is same as well as the grounds are same. And for this simplicity, we can remember and relate here article number 124 clause 4 and 124 clause 5, which are with respect to Supreme Court, plus article 218 with respect to High Court, and it states that the provisions for the Supreme Court will also be extended to the High Court. Which provision? Article 124 clause 4 and article 124 clause 5, because these are the two main clauses which talks about what will be the procedure for removal and what will be the grounds for removal. And as a result, these two are extended for High Court by article number 218. This is why the procedure and the ground are similar for removal of the judges of Supreme Court and High Court. So what is the ground for removal? In terms of the ground for removal, it is one called proved misbehavior, or another one is called incapacity. These are the two grounds which are provided in the Constitution for the removal of the judges, and these are provided under article 124 clause 5. Whereas the procedural side is said, in order to remove, we require resolution passed by both the houses, by special and absolute majority. So both houses are required to pass this resolution by a special and absolute majority. This becomes one of the most important keyword in order to remember this procedure for removal of the judiciary. Let us understand in detail what actually is proved misbehavior, what actually is incapacity, and how in case of incapacity there may be requirement of a medical board, because how you will determine that it is medically fit or unfit, because incapacity is something related to health scenario, and proved misbehavior can be related to the conduct, corrupt practices, abuse of authority. In that context, these two terms are mentioned in very broad perspective. Plus, this removal is also supported by a law. Reason, Constitution also authorizes the Parliament to make a law and regulate the removal of the judges. And therefore, one statutory provision also exists which is popularly known as Judges Inquiry Act. 1968. All these together will decide about removal of the judges. Let's understand these procedures one by one. First of all, when there are complaints about misconduct, this misconduct will become a ground for proved misbehavior, and there will be internal inquiry. This internal inquiry will be done by judiciary itself. So, Supreme Court, CJI, they usually get this complaint about the misconduct of a judge, and thereafter the internal inquiry is conducted. We have seen this committee was constituted in 2025 beginning only, when the cash allegations were observed with respect to a High Court judge. And that inquiry committee has in the last 2 months submitted their report, and they found that the judge was guilty. So, after this internal inquiry, the committee will recommend that what will be the future course of action, and they recommended the judge should be removed, otherwise he himself can submit a resignation. If the judge himself has removed, there will be no requirement by a procedural formality through the from the parliament. So, judiciary himself can submit this resignation. However, if there is no such action by the judiciary, then comes the role of legislature or parliament. Because this power is exclusively in the hands of the parliament for both Supreme Court as well as High Court judges. And from here will be the procedure for removal of the judges followed in the parliament. In this context, the first thing is a notice for removal of judge. This notice is to be given to the presiding officer of the house, but depending upon in which house you are submitting the notice, the support of member will be required. If this notice is given in Lok Sabha, so you require a support of minimum 100 MPs. If it is introduced in Rajya Sabha, so it requires support of minimum 50 MPs. That means in any of the house, the notice for removal of a judge will be given. That will become a step 1 at the level of the parliament. After receiving this notice, the presiding officer here it will be speaker or a chairman. In whichever house it has been introduced, the presiding officer of that house is going to constitute a committee. So, this committee will be a 3-member committee, and this committee will be responsible to frame the charges. Means what are the violations done by the judge. On that basis, this committee will be responsible to frame the charges, and it will usually have 3 members. One will be a retired or sitting judge from the Supreme Court, a High Court, retired or sitting judge of a High Court, and a third person can be eminent jurist. So, eminent jurists are also the people with a good law standing. They are the law expert, and they have contributed in the law academics or maybe working in that field for a longer duration, and they will be considered under the term eminent jurist. So, it is a 3-member committee which will be constituted by the presiding officer of the house wherever it has been introduced. Then this committee is responsible to frame charges. And if there are grounds of proved misbehavior, then only this committee will be working. And before this committee, there will be opportunity for the judge to defend in writing. It's like committee is framing the charges and we are seeking a reply from the judge also, so that what are the charges against you and what you are supposed to say over these charges. If the judge is able to convince the committee that there is no violation, no proved misbehavior, so their committee can even end this procedure here and there will be no further steps. That means this inquiry by the committee can result into 2 options. One, they may find the judge guilty, or they may find the judge not guilty. If the judge is guilty, the process will continue. If the committee is of this view that the judge is not guilty, the process will end here only. So, how the process will continue? That will be done in the form of resolution. That means the house in which this matter was introduced, let us say it was introduced in Rajya Sabha. So, Rajya Sabha is going to pass resolution. This resolution will be passed by a majority of not less than 2/3 of present and voting plus more than 50% of total strength. This is why this majority is called as special and absolute majority, where this part is special and that part is absolute. So, it becomes a combination of special and absolute majority, and once it is passed by one house, then this other house also have to pass the resolution by special and absolute majority. So, both the houses have passed the resolution and thereafter the matter goes to President and President order will be issued about removal of judge. That is how this process works in the context of our country for removal of judges. However, this was a procedural requirement with respect to the judges with proved misbehavior ground. If there is another ground which is called incapacity, then one extra step will also get added. If it is a matter of incapacity, so with respect to incapacity, there is one additional condition, and that condition is there should be a medical board. So, basically medical board is a team of doctors, and this medical board will be constituted by the presiding officer in the house where this motion has been introduced. So, if it was introduced in Rajya Sabha, chairman will constitute this medical board. If it was introduced in Lok Sabha, speaker is going to constitute this medical board, and this medical board will declare unfit to continue in the office, because it is possible that the person might have been suffering from coma, might have lost the mental balance, which is called person of unsound mind, and in those circumstances the person cannot discharge his constitutional obligation as a judge. And in those circumstances, the medical board certification is important, and thereafter the procedure will remain similar. That means the first house, second house, both have to pass this resolution, and thereafter the final matter goes to president for removal of a judge. So this become a procedural formality for removal of judges of Supreme Court or High Court in the context of our country. I hope this will clarify about the removal of judges of Supreme Court and High Court in our country, and it is one of the recent current topics which is there, very useful for the polity and governance. Thank you so much, and see you in a next video in future. Have a good day.